Lesley Fair. I'm a senior attorney with the Federal Trade Commission's Bureau of Consumer Protection, and you're listening to IP Fridays podcast.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more. Welcome to episode 117 of the IP Fridays podcast. I'm Ken Suzanne, co-host of the IP Fridays podcast, along with Rolf Claessen. If this is your first time listening to the IP Fridays podcast, welcome. And if you're a returning listener, thank you for coming back. If you enjoy our podcast, please help to spread the word on social media and through word of mouth. Our guest today is Lesley Fair. Lesley is senior attorney with the Federal Trade Commission's Bureau of Consumer Protection. Before we get to today's interview, let's focus on a recent development from the Federal Communications Commission and its Emergency Broadband Benefit Program. In an effort to expand high-speed internet access to low-income residences across the United States, the Federal Communications Commission has announced the Emergency Broadband Benefit Program, a $3.2 billion federal initiative that provides eligible households with discounts up to $50 per month for broadband service, $75 per month for households on tribal lands, and a one-time discount of up to $100 on a computer or tablet for eligible households. Program eligibility includes low-income households who already participate in low-income or pandemic relief programs established by broadband providers, Lifeline subscribers, including those on Medicaid or those that accept SNAP benefits, households with children who receive reduced price or free school breakfasts or lunches, Pell Grant recipients, and those who have lost their jobs and seen their income reduced in the last year. The FCC's acting chairwoman, Jessica Rosenworcel, stated that, quote, "This program will help those at risk of digital disconnection. It will help those sitting in cars and parking lots just to catch a Wi-Fi signal to go online for work. It will help those lingering outside the library with a laptop just to get a wireless signal for remote learning. It will help those who worry about choosing between paying a broadband bill and paying rent or buying groceries. In short, this program can make a meaningful difference in the lives of people across the country," close quote. Now on to today's interview with Lesley Fair. Our guest today on the IP Fridays podcast is Lesley Fair. Lesley Fair is a senior attorney with the Federal Trade Commission's Bureau of Consumer Protection. After litigating false advertising cases for more than 20 years, she now specializes in industry outreach. She is the primary author of the FTC's business blog, which the ABA Journal named to its Best Law blog list. She has received the Robert Pitofsky Lifetime Achievement Award, among the highest honors for a career FTC staff member. Lesley serves as a vice chair in the American Bar Association's Antitrust Law section, on the faculty of the Catholic University School of Law since 1984, she holds the title of Distinguished Lecturer. She also teaches consumer protection law at the George Washington University Law School. Lesley clerked for the United States District Judge Fred Shannon in San Antonio, Texas, and served as staff counsel to the United States Court of Appeals for the Fifth Circuit. She is a graduate of the University of Notre Dame and the University of Texas School of Law. Welcome, Lesley, to IP Fridays.
Thank you, Ken. It's a delight to be speaking with you.
Lesley, can you tell our listeners about the FTC's Bureau of Consumer Protection? What is its mission, and what are the typical matters that it handles on a day-to-day basis?
I think most IP professionals are familiar with the other half of the Federal Trade Commission, the Bureau of Competition, which deals with antitrust issues, obviously. We like to think of FTC standing for both for thriving competition as well as for the consumer. So the consumer protection side of the FTC, we deal with challenging unfair, deceptive trade practices in the marketplace, certainly scams and frauds, but also illegal business practices by Fortune 500s and other large corporations.
Mm-hmm. And you've been with the FTC for 20 years, for more than 20 years. How has the FTC changed during that time period?
I started, Ken, in 1987,
wow.
which was before the dawn of Internet history. And so, I thought the job was tough and challenging back then, when all we had to deal with was television advertising, radio advertising, direct mail, things along those lines. And, of course, the world changed when with the digital revolution. The interesting thing is the size of the FTC staff has not changed. So we are virtually the same size as we were when I started in 1987. However, as a cop on the beat, if you will, in the marketplace, we have the same number of staff, but the biggest change, of course, has been what the FTC has done and continues to do when it comes to the digital marketplace. And I think that's been a major change, obviously, for your clients and a huge change for what the FTC does.
Is there a certain type of issue that you're seeing more of today than you didn't see a number of years ago?
Well, for the most part, issues of data security and consumer privacy were not as upfront as they are now. We have a division of privacy and identity protection that was founded about 20 years ago. Now, that's not to say the FTC hasn't always had an interest in data security and consumer privacy. I would go back to a statute we've been enforcing for 50 years, the Fair Credit Reporting Act, which does have very specific consumer privacy and data security provisions. But I think what I wouldn't have predicted when I started at the FTC in 1987 is the extent to which questions about data security, consumer privacy, and the ongoing big data debate, however you want to define that phrase.
Yes.
I don't think anybody could have predicted that direction. But that makes up for a lot of what the FTC does these days. Not the only thing, but certainly data security and privacy are huge parts of our mission to both, on the antitrust side, to encourage competition in the marketplace, and also on the consumer protection side, to make sure that the flow of commercial information, that it flows both, cleanly and freely, which I think is how the Supreme Court has worded it over the years.
Yes, and let's move on to the word scams, which I'm sure takes up a lot of what you do. Particularly here now with COVID-19, I understand that there are a lot of scams happening. What are some of these scams that you're seeing? What can businesses and consumers do to protect themselves?
I think that, this time last year when we were preparing our planning and our budget, your clients, of course, weren't expecting the massive change to their business. And we had really, no way to predict that too. But our mission in so many ways on the consumer protection side has really shifted in focus. Certainly, we're still bringing, and in the same record numbers, the kinds of cases we've always brought. But the prevalence of COVID scams has taken over a big chunk of what we do. So far, the FTC has sent more than 350 warning letters to companies.
Wow.
And these, now, some folks have said, why not file 350 lawsuits? That's because we're spending taxpayer money.
Yes.
350 lawsuits are difficult to do. And I think we've had real success with this warning letter system. Basically, what we've done is, we have all of us on staff, looking for the kinds of questionable practices that we're seeing. These might be cures, preventions for COVID, treatments for COVID. That's one thing. And so we've sent those 350 letters to companies basically saying, listen, we spotted what we think are some questionable practices on your site. We want you to get a hold of us within the next 3 days, and we certainly hope that you will take a closer look at what you're saying. I call these just slightly facetiously, letters from the FTC, the friendly Trade Commission, because we send those letters out with the presumption that some of the companies that are engaged in these practices may be relatively new to the marketplace. They may have rushed in. They may not have talked to counsel before entering the marketplace. And generally speaking, we've had good success in companies then taking down those questionable claims. Now, when companies have refused, we have a number of cases against purported cures and treatments that are in litigation right now. And so that's one large area, what we're seeing. Mm-hmm. We're also seeing a number of issues dealing with shipment of personal protective equipment. The FTC enforces the mail, internet, and telephone order rule. That, to me, is really the key regulation that has made online commerce possible. Because for the most part, when we click an Order Now button, most of us have great success in maybe even overnight, but at least in a few days, getting the items we ordered. Now, we absolutely appreciate for businesses that there have been disruptions in the supply chain. And we get that, and the mail order rule understands that. So if a company, in good faith, makes the claim that they have items in stock or have items available, these might be masks, disinfectants, the kind of things that everybody's looking for right now. There's an easy way under the mail order rule to just notify customers and saying, listen, we're having a supply hiccup. Do you want to wait or do you want us to cancel the order? That's simple. What we're seeing, however, is a number of companies going online, setting up websites that claim to have ready access to those N95 masks people are looking for, or other kind of personal protective equipment. These yet are not shipping, or are shipping weeks or months after the fact. Mm-hmm. Our allegation in pending cases is that this has certainly harmed consumers, but it's also harmed a lot of small businesses, doctors' offices, or nursing homes, or daycare centers that need those kinds of things to be able to do their work. The other very interesting case we currently have pending is a case against a group of people that basically spoofed the website of well-known disinfecting products. So consumers thought from the spoofed URL and the look of the page that they were actually on a website of Clorox and of Lysol. So consumers thought, oh my gosh, I finally have access to the cleaning supplies I haven't been able to get.
Yes.
They placed orders, and the companies that set up the websites took the money and ran. And this, of course, harms certainly the consumers who lost money. But in this case, we also think who else was harmed was Clorox and Lysol.
Yes.
So, as a general rule, and here's the news that IP practitioners might not want to hear, as a general rule, the FTC's job is not to enforce the IP rights of companies, many of which have more lawyers than the Federal Trade Commission has. But our job is to protect consumers. So in that case, we certainly thought it was consumers were being injured, but also the companies whose good names had been spoofed and had been stolen.
Yes.
The other big bucket of scams that we're seeing are ones especially aimed at small businesses, I guess, and some consumers who are really struggling to keep their head above water financially. I think a lot of folks are aware of the SBA's various loan programs, and what a lot of what some bad actors have done is set up websites using URLs that appear to be from the SBA, are collecting companies' quote-unquote applications, and actually have no affiliation with the SBA or those loan programs at all. And so those small businesses find themselves out of luck. So I think those are kind of the three buckets of the kinds of deceptive practices that we have seen and that we're trying to do something about.
With respect to those spoofed websites, was there litigation filed, I think you said?
Yes, the case is pending. And this was an interesting case because we named we named unnamed defendants. We went in because one of the interesting parts of the case will be trying to figure out the source of these websites. They tended to go up for a short period of time, collect money, shut down, and then open up elsewhere under a slightly different name. And so I know that scammers who engage in that kind of conduct think they're fooling us. Not so. The FTC has some very sophisticated online investigative abilities. We also have some real, kind of tech, I'll call them sort of CSI tech experts, in our secret internet lab bunker, that they are able to do the kind of investigations we need to track down folks who are doing their level best to avoid detection. So that was an interesting case in that it was brought against the unnamed, entities that were using these spoofed websites.
Well, it's good to hear that the FTC is cracking down on those types of websites. I know that many consumers and brands are hurt by those types of websites, so good to hear that. What if one is a victim of an online scam? What can people do? Is there a way to report things to the FTC? I think there's a website. There
is, Ken. Reportfraud.ftc.gov is the place to go.
Okay.
And let me make it clear: a consumer or a business does not actually have to be victimized by the fraud to report it. So if a good citizen spots something online that looks very questionable, we welcome them to file a report online to us. We operate something called the Consumer Sentinel Network. It is with multiple law enforcement agencies across the United States, everybody from local police departments investigating identity theft to obviously the Federal Trade Commission. We put all of those reports from consumers in one central confidential database reserved only for law enforcement, and we use those reports to help make our cases. And so, we publish, without the names, obviously, but we published daily, for example, the number of COVID reports we have received. I think the latest number is about 350,000 that we have received from consumers in the past 11 months or so. And so, that is a really useful source of information because a consumer may think they're the only one that has been victimized in this way, but by letting us know about it, by being deputized to be our eyes and ears in the marketplace, they can let us know information about what they spotted that can help us put together cases, and if not us, can help the state attorneys general or the local police department make more effective, have the evidence that we need to go to court to make a more persuasive case. So reportfraud.ftc.gov is an easy way for consumers to let us know what they're seeing. We also are very open to hearing from businesses. The site is called Report Fraud, but I want to be real clear. We accept reports about things that might not legally be classified as fraud. Any kind of questionable practice. And so if a business sees a questionable practice engaged in by their competitor, and who hasn't, they're welcome to contact us, to let us know what they've seen. And so there are, one of the things they can do is simply contact me personally at lfair@ftc.gov, and I can kind of send them to the right person to talk to. But a number of our cases, although I can't say which, have been brought after an independent FTC investigation, but based on a tip that we received from a competitor. Because who knows more about what's going on in the marketplace than the competitors? And how often have lawyers in this area had to deal with clients who've said, you've told me I can't do this, yet look at what our competitor is doing. Maybe I need one of those nice lawyers who will let me violate the law. And so we want to be supportive of attorneys who are counseling their clients wisely to let them know that if there are competitors out there not playing by the same rules and cutting corners, we're all ears and we'd like to hear about it.
We'll put a link to reportfraud.ftc.gov in the show notes so that listeners can directly click on that if they need to.
Thank you.
Let's shift the focus to privacy. How does the FTC regulate privacy issues with respect to the Internet?
Regulate, let me just underscore or put a little asterisk by that word. Mm-hmm. Interestingly, the Federal Trade Commission is actually a law enforcement agency, not a regulatory agency. Now, why am I making that very law school-like sort of distinction? The FTC does not have authority under the Administrative Procedures Act to promulgate regulations. That's why. And so now, that doesn't mean we don't have regulations that we enforce, but the more common way is that Congress will direct us to promulgate a rule, as, for example, it did in the year, I guess it was 1999, when it said to the FTC, we don't want businesses to be collecting information from children online without parental permission, so do something about it, FTC. I call this Jean-Luc Picard rules, make it so. And so, Congress did that, and that's how the Children's Online Privacy Protection Rule came about. So,
yes.
Certainly we have several rules under the Gramm-Leach-Bliley Act, the Safeguards Rule, and the Privacy Rule. We have the Children's Online Privacy Protection Act. But most of our privacy cases, Ken, have come out of the standard tenet of FTC law, which is that companies must honor the express and implied representations that they make to consumers. Now, whether that is this will prevent you from getting COVID, this will increase your income, or we promise not to share information with third parties without your express consent, we apply the exact same law across the board to those. It's a statute written in 1915. It's had one revision, one amendment since then in the 30s, but it says unfair or deceptive acts or practices affecting commerce are hereby declared unlawful. Section 5 of the FTC Act. Mm-hmm. So most of our privacy cases are brought under that rubric, that companies have engaged in practices, have used consumers' personal information in a way that the FTC alleges is either deceptive or unfair. And we've brought a number of big cases over the years. I'm thinking of the $5 billion with the B dollar Facebook settlement, for example, that was brought under that rubric of unfair, deceptive acts or practices are hereby declared unlawful. So we look at what companies say expressly and by implication on their websites and in their privacy policies with regard to how consumer information is going to be used. And then if those practices are either misleading or unfair, we will use our standard jurisdictional authority to challenge those practices, just as we would a false advertisement. Mm-hmm. And so a lot of what we do recently has certainly dealt with consumer privacy.
Focusing on the online experience and enforcement, I understand there's something called the Restore Online Shoppers Confidence Act. What is that act, and can you give me any recent examples on how the act was enforced?
ROSCA, as it's called, deals with those pesky negative options that consumers who think that they may be responding to a free offer online, let's say, and yet are actually being signed up without their express consent for a monthly shipment and billing of a product.
Oh, yes. I hear that happens a lot.
Happens a lot. It is particularly annoying. Now, certainly, some of these companies are, are very questionable and are selling stuff that, we also have problems with the underlying nature of what they are peddling. But a lot of it is too. We've brought a number of cases too against companies that are in what some people call, the front door economy. I don't think there is anything that we can't get delivered these days. And certainly in a time of COVID, that's been a lifesaver for many of us.
Oh, for sure.
But one example in a case involving, again, an established company is a company called Adore Me. And they offer, both kind of casual wear, exercise clothing, lingerie for women. But the FTC's allegation was that, and they sell, every month, consumers are billed for the product, and the FTC challenged under ROSCA the operation of their mailing. So that's an example, again, not of a company peddling a bogus diet pill that way, but a company that we alleged they needed to tweak their business model to make sure that they were honoring all of the points of ROSCA. One of the important aspects of ROSCA, and this was brought up in a recent case involving some online educational materials for kids, is to make it easy to cancel. A lot of companies say that all the time. Sign up, it's easy to cancel anytime you want. And yet a number of companies make it virtually impossible to figure out how to cancel. A number of them will accept cancellations only by phone, but don't publicize that phone number. Or accept them only by email, but not through a general email box. You have to email a very specific email box that, again, is not publicized. So it is not illegal to engage in these kinds of negative options, but ROSCA requires very, very clear disclosures up front to consumers, and it requires companies to honor quickly and easily the request of consumers to complain. One of the first things we'll do, of course, is to, undercover sign up for this service and then try to cancel. And, once we're on hold for 45 minutes, maybe that's kind of a sign that a company could have a ROSCA problem.
Sure. With the Internet being global, does the FTC ever enforce U.S. laws against individuals or entities located outside the U.S.? Do Internet shopping and scams fit into that as well?
Well, I guess we do that in two different ways. We do have an Office of International Affairs at the FTC that works cooperatively with our brothers and sisters at other agencies across around the world.
Okay.
And so we work very regularly because, let's face it, once a company may shut down in the United States, we don't want to see them using those same tactics against Canadian consumers or consumers in other parts of the world, and vice versa. So we think having those very close ties is one way to try to crack down on illegality. There's been a lot said and a lot the FTC is doing with regard to robocalls, which are illegal, yet are often coming from sources outside the United States. When companies have assets in the United States and are targeting United States consumers, those are easier cases to bring. For companies that don't have a United States presence, we're more likely to try to work with our counterparts in that part of the world to try to do something about it. But I can say, there's a very good statute, the U.S. Safe Web Act, that encourages this kind of cooperation. But it is one of the difficulties in Internet commerce. We see this, again, robocalls, as I mentioned, and social media, too, that a number of the issues involving illegal social media practices, we've had concerns are coming from places outside the United States.
You mentioned social media. Does the FTC regularly review, social media on their own for violations, or do they rely upon reports from others? How does that work?
We do both. And I think the important thing that companies should remember, a lot of companies are very careful about making sure that they contact people like you, Ken, or other attorneys to review their marketing materials before they go out. That's kind of the smart, prudent thing to do.
Yes.
Obviously, to make sure trademark stuff is taken care of, but that's why I love talking to IP attorneys, because they are very often the de facto consumer protection attorneys. But one of the things that we remind them is that their social media presence is also subject to the false advertising provisions of the FTC Act. So what they say on Facebook, what they tweet, what the influencers that they hire to as part of their marketing efforts, what those influencers say is their responsibility. The most important provisions are under the FTC's guides for the use of endorsements and testimonials, which long predates social media, but it says two important things: that an influencer or a blogger or a tweeter, an Instagrammer can't say something about a product that the company doesn't have, the advertiser doesn't have proof to support.
Mm-hmm.
So you can't slide that in the side door by having it come from someone else.
Some sort of substantiation, right?
That's the key factor, yes. And that applies, again, TV, internet, direct mail, social media. Companies must have, before a claim goes public, must have in hand competent and reliable evidence to support that.
Yes.
That's kind of the foundation of what we do. That was the reason for example, all of those COVID warning letters. What's your substantiation? The other angle that comes up in the influencer context is it clear from the nature of the tweet, the IG, the blog, etc., that the influencer is working on behalf of the company? And so we call those material connections, and we think consumers have a right to know that. If you go to a website and it says Lesley Fair is the best lawyer in Washington, D.C., that might be influential until you find out that it's my mother's website, right?
Mm-hmm.
So we think that kind of connection is important for consumers to have, to allow them to factor in, to what extent is that going to factor in to the credibility they give what the influencer may have to say.
Mm-hmm.
And so we've done a lot in recent years in social media. But the important thing for companies to know is that when we're looking at their advertising claims, that includes what they're saying on social media.
We're coming near the end of our time today on IP Fridays. Lesley, could you give our listeners an idea of the online resources that the FTC has to find out more information about issues that we've talked about today?
We have a lot of online resources, Ken. These are plain language, to the point brochures and guidance documents that can walk businesses and attorneys through what the FTC law is. Certainly we have our ftc.gov website that offers kind of the news of the day, but we have a special portal for business people and attorneys. That's business.ftc.gov, and there businesses will find more than 200 plain language guides: how to deal with disclosures in a digital environment, what if they want to sell dietary supplements, how do influencers need to disclose their connections. All of those questions are answered at business.ftc.gov. We also mentioned, and I will, in the interest of full disclosure, reiterate what you said, that I am the FTC's primary business blogger. But the business blog goes out usually between 2 or 3 times a week to give a very informal take, the takeaway tips for businesses about FTC's actions and initiatives and cases. I will be, I am proud to say most people who look at it ask themselves, are you sure this is a government website? And that makes my day when they do that. I think the only time I may have crossed the line is when I explained the provisions of the Fair Credit Reporting Act, the FCRA, to the tune of the Village People's YMCA. Maybe that crossed the line. But I can guarantee you this is a blog like no other, and you can subscribe at ftc.gov/subscribe to business alerts. So between business.ftc.gov and the business blog, it's an easy way for companies to keep up to date.
A wealth of information indeed, Lesley. I really appreciate you taking the time with us here on the IP Fridays podcast. Thank you so much.
Thank you, Ken.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.